It's going to differ. There's going to be some days where I'm involved in something that's a full day experience, such as taking a deposition, being in a hearing or trial, or being at a mediation. More often, my days are a mix of things. A lot of times talking to people, either meeting with somebody when they first come to me with a problem and doing a consultation. It might be follow-up calls with clients. It might be calls with adversaries to try to resolve an issue, to work out a discovery fight, editing things that associates have drafted, and even though I'm managing partner, I still draft things myself, drafting part of a brief, drafting a complaint to file in court, things like that. I mean, I'm a litigator, but being a litigator doesn't necessarily mean that you're actually in a courtroom all the time, so I'm doing things that are litigation related, like asking for documents, producing documents, taking depositions, defending depositions. But I will have conferences with judges, arguing over fights over discovery, arguing dispositive motions, and then some things do go to hearing either in court or in arbitration. I've probably done, a couple dozen, at least a dozen jury trials as well as numerous arbitrations. There's a few things. The law is constantly evolving, so it's not static. And there's also opportunities for pushing the law in new directions. So our firm, prides ourselves on finding new areas. So, an example from a couple decades ago when the Americans with Disabilities Act was new, we represented somebody that wanted a parking spot near work, which in New York City is a rare thing. And so we were fighting for the argument that the employer had an obligation to help her get to work. And their argument was they had no obligation to her until she made it through the front door on her own steam. And we took it up to the Second Circuit, and the Second Circuit said, in appropriate circumstances, the employer might have to help somebody get to the workplace. So it's those sort of exciting opportunities to expand the law that's very interesting. And I like working with people. A lot of people come out of law school and say they want to do class action litigation because those are the big, sexy cases. But then you're talking to a lot of experts and dealing with statistics and policies. I'm dealing with people who've come to me, and they might not even come to me talking about a legal claim, but something bad has happened to them or they're in a difficult situation, and my job is to help them get a resolution for that. So, it can sound hokey, but I'm helping individuals on a daily basis. I think one of the challenges is it's individuals. So, no one likes to lose a litigation, but when the company loses, in most cases, they can move on easily from it. It can be really devastating for my clients if they lose. And there are times where you think you had justice on your side. In an employment discrimination case, you think you were a better lawyer, and you lose, and the client is economically damaged. They're emotionally scarred by what happened. It's very difficult. But those are the times where I say, what else could I be doing? But so far, at least, I've woken up the next day and continued on. I went to law school knowing that I was interested generally in civil rights and civil liberties. I didn't go to law school knowing anything about employment law. I didn't really know any lawyers. I think one of the key things was, one of the great things I went to NYU Law School, I was in New York City, is I interned at the ACLU, I interned at what used to be called the Now Legal Defense Fund, I interned at Legal Aid. I experienced lots of different things. And so after law school, I clerked for a federal judge for a year, which was a great opportunity for someone that wants to be a litigator. I then had a fellowship for 2 years at the Now Legal Defense Fund, doing women's rights issues, which was great, but they didn't have the money to keep me after the fellowship ran out. And one area I stumbled upon was that, there are private lawyers that represent employees in discrimination cases, something It can be hard to figure out because a lot of the big law schools are great with the big law firms and they're great with the big public interest organizations, but small firms that do public interest oriented work is not something you necessarily learn a lot about. So I got some exposure to that and came to my firm, and I've been there for 31 years now. I mean, I think once you get past the basics that law school teaches you about, contracts and torts and corporations, and even if you're doing public interest law, you have to know corporations because you're suing them, you have to understand them. I don't think the particular courses you take matter as much, but I do think, as I said, I spent law school working at a lot of different organizations. So I got a sense of what it's like to work at a public interest organization. I spent one summer working for a sole practitioner in Massachusetts. I spent half of another at a big firm in DC. I got to see what different experiences were like and figure out what I liked and what I didn't like. It can be hard because the firms on my side are small. It's not like we're going to be hiring an incoming class of 25 lawyers. We have 12, 13 lawyers in our firm. So you might not be able to find something with a firm like mine right away, but there's other opportunities. You could do other litigation to get those skills. There's governmental agencies. People, the Attorney General's office has employment law units. Places like the Legal Aid Society have employment law units. There's ways where you can be doing something civil rights oriented and maybe employment related and getting litigation skills. It's going to put you in a good position to move into doing what I do, representing people in the private sector.